Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
A Faith and Freedom listener emails in with a tip about United States Supreme Court Justice Stephen Breyer. We're going to talk about that on Faith and Freedom today. I'm Matt Barber, Director of Cultural Affairs with Liberty Counsel and Associate Dean with Liberty University School of Law. Joining me in studio is Sean Akers, Dean of Liberty's Helms School of Government and Policy Analyst with Liberty Counsel. Sean, we received an email from one of our regular listeners here on Faith and Freedom indicating that this gentleman had been listening to the Diane Rehm show on NPR, where he heard Justice Stephen Breyer talking about the United States Constitution as a living document. And that was a quote. If you go to the Diane Rehm website and read their description of the interview, it says Supreme Court Justice Stephen Breyer discusses how the nation's highest court can maintain the public's confidence, his perspective on the Constitution as a living document, and his pragmatic approach to deciding cases. Well, Sean, we had an opportunity to listen to the interview. Justice Breyer is very clever and very nuanced in his approach, but he does address and represent this living, breathing model of the United States Constitution that we have discussed here on Faith and Freedom a number of times, versus the originalist view, which is held by judges like Justice Scalia, Clarence Thomas, Chief Justice John Roberts, Samuel Alito, and so forth. And these two interpretations of the United States Constitution are really at odds, Sean. And I think the living, breathing model that Justice Breyer holds and has articulated, this pragmatic view, and of course pragmatism is a term which really is a euphemism for pragmatism, saying it is whatever I say it is. And, former United States Chief Justice Charles Evans Hughes, I think, summed up this view best. He served as Chief Justice from 1930 to 1941. He had this to say. He said, quote, "We are under a Constitution, but the Constitution is what the judges say it is." Well, Sean, that living, breathing viewpoint of the Constitution that Chief Justice Evans and certainly Justice Breyer hold, I think, have been responsible for a number of horrific decisions that have come out of the United States High Court over recent decades. And it also is taking us down this path toward complete judicial relativism. If the Constitution is what the judges say the Constitution is, then the Constitution is nothing at all.
That's exactly right, Matt. I mean, it's a wonderful, wonderful thing that our listeners have become so in tune that the moment they listen to one of these interviews, they say, wait a minute, I know what they're talking about. He said that's a living document. I know what that means. And really what we're getting at, Matt, when we talk about this strict constructionist view, this original intent view, and this living document view, is really a question of power. The question, Matt, that everybody tries to sidestep here is who drafts the Constitution? Who is speaking? Because if it's a living document, that means that it's constantly subject to revision. Let me show you a quick example that'll probably clear it up some. If you go out and sign a contract to buy a car, you're betting that it is a strict constructionist point of view on that contract. Because when you leave, you expect to pay what you agreed to pay in the increments you agreed to pay them at the interest rate that you agreed to pay for the number of months that you agreed to pay under the conditions of the contract. You need to be able to rely on that document. Now, if that contract happens to be a living contract, then you may have a problem because somebody somewhere may decide, you know what, that really wasn't a fair price for that car. You need to pay pay more. Or economic conditions have changed. Maybe your interest rate should be more. Or, I tell you what, we'll leave all that the same, but because people are living longer now, maybe you should pay more months. At any rate, the contract that you sign has very little to do with the living document that you now have to deal with. And that's really where we are. We, the people, spoke as a united body. And they left a way. We have a way to change what the Constitution says. It's called the Constitutional Convention. You can make amendments to the Constitution. It's not supposed to be easy. It's supposed to be difficult for the very reason that you can rely on that document. This living approach that our listener was very keen to catch with one of these justices says just the opposite, that like changing that contract, well, we decide as judges it's a living document. We decide what it means. And when they do that, Matt, what happens is it's just like pulling out the 200-year-old quill and rewriting a section of the Constitution.
Yeah. And circumventing completely the amendment process, which is the constitutional process, as you pointed out. We call this judicial activism. People hear that term thrown around a lot. What does judicial activism mean? Well, that's the definition of judicial activism right there. Is taking the Constitution and making it say what you want it to say because of some subjective ideological position that you hold. That's where, going way back, the Dred Scott decision came from, that said that African Americans could be property and had no personhood rights under the United States Constitution. That decision is a blight on American history. More recently, you have the Roe v. Wade decision, which is the same thing. Judges finding a kind of a very ambiguous and overbroad so-called right to privacy that included the right for a woman to kill her completely separate, as an individual child, that just simply because that child was an inconvenience. This is judicial activism. The first real outspoken critic and opponent of judicial activism was Thomas Jefferson. In 1819, he warned, Sean, that the Constitution could become, quote, a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. Well, sure, that's very convenient to look at the Constitution in that manner. If you happen to be a person that wants to twist it and shape it to be whatever you want it to be and to say whatever you want it to say, that's the living, breathing model of the Constitution. And it could be a two-edged sword, except that typically conservatives hold a originalist view, and they exercise judicial restraint and do what they're supposed to do: interpret the Constitution through the prism of original intent, rather than through the prism of subjective, changing whims of the day.
Well, and the problem with this, Matt, is that those who want a living document are the same ones that want to use government. It's a very general principle. Some ideologies want to be able to use government to make the world what they want it to be. Others want to recognize principles that allow people to become all that they can be under the principles. So when you've got a Marxist mindset about all things, what you're really talking about is government's power to redistribute wealth and power. When you can rewrite the Constitution, when you can decide it on a whim, when you literally, as the president has said, that he'd like to appoint justices that could empathize with certain segments of society, what you're saying is we want to be able to redistribute according to our own will, that this living document approach gives us the ability to move power, to move rights and responsibilities, to move rights to those that we want to have rights, and saddle with responsibility those that we want to saddle with responsibility, the same way that Marxist mindset in the economy says we want to give from those who have according to their ability to produce. We want to take from them and give to those others who need according to their need. This is straight Marxism. Yeah. And unfortunately, That's not the way the United States was designed. It was designed to put everybody not on an equal finish line, but on an equal starting point.
Well, that's exactly right. And almost without fail, the secular humanist / neo-Marxist holds the viewpoint that the Constitution is living and breathing, because the true interpretation of the Constitution, the originalist viewpoint, makes the Constitution an encumbrance. John Adams, the second president, said this, quote, "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other." And folks, this living, breathing interpretation of the Constitution that is held by these secular humanist neo-Marxists, that is employed by these same types of individuals, has taken us very far away from the original intent of our founding fathers. Go to lc.org to learn more about what we're doing to defend the United States Constitution.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.